But an arbitration proceedings was filed before this bench. Subsequent, an arbitration proceedings was filed before this bench.
What proceedings? Are we
No, no,
section
no.
9, section
No,
11?
section 11 for appointment of an arbitrator. Subsequently, the matter was taken up and the matter was disposed of. Now, my lord, the original agreement, partnership agreement, still forms a part of the record. My lord. For return of that agreement, my lord, I am mentioning this matter.
Return of the agreement.
Original agreement. My lord. Yeah, hand over.
Why are you mentioning?
My lord, the department.
Are you aware about the procedure? Your appellate side rules clearly says you give a local copy, the department will return you that.
But I shall do the same.
You have to give a local copy,
No.
but you should have indicated, you shouldn't have annexed the original agreement with the section 11
No, the
application.
department refused to accept the while filing of the said application. My lord, the department refused. My lord.
True copy now, because this creates a problem.
Yes.
The true copy is sufficient enough.
My. I should.
You see, you talk to them. After, if it is not resolved, you come back.
Great.
Better dissolution application for the expeditious trial of the expeditious interim application, tactic matter lordship.
Yes.
Guardianship matter lordship.
Guardianship matter.
Subsequently, lordship, Honorable Justice Vishnu send the matter for mediation. And mediation failed, lordship. For mentioning for listed for hearing, lordship.
Look into it. Give the slip. Are you mentioning about notice?
Yes. Earlier advocate, he is appearing on behalf of the OP has served the
Where is he? What is his name?
Mayan Roy. Earlier who were mentioned this matter. Earlier matter. Earlier, there's
Why earlier? There is a change in advocate.
no. Earlier the advocate mentioned the matter. He is appearing on behalf of in this matter. Behalf of the
Just now.
yes.
So,
I see. Also give the notice.
Should we mention a matter for inclusion in the list? It's a civil motion stage. It's a transfer matter. So the husband filed a divorce matter in the Deputy Board of Planet District Judge of Jalpaiguri, and the petitioner being the wife.
when did you file this?
In the year of 2024.
What has happened in between?
The Honorable Coordinate Bench granted me stay.
Stay of what?
Stay of the proceedings, Lordship.
Yes. Stay of the proceeding.
You have start the copy to the opposite part. Kindly this the matter and we are the.
When was the last order passed?
In the month of
February?
February 2025.
When was the returnable date given?
We are starting. Kindly Lordship, take the matter, Lordship.
Yesterday you found one 24 application has been allowed by me, so you have been encouraged by that. You are sitting tight, watching from the fence.
But I would not get. Kindly Lordship, take the matter.
Are you mentioning upon notice?
We have start the copy to the opposite party.
Service will not do. Today I list the matter. It will not inure to anybody's benefit because the person will not be there. Again, I have to give them a notice. Why should I allow you to mention upon notice? I do not allow mentioning without notice. If it is a first time, then you are not sure who is appearing. But now you are sure who is appearing. Give him a notice.
Permitted to second appeal stay application. One substantial question obtained by the division bench, honorable division bench. They are directed to matter stay application will be heard by the honorable.
Yeah, I do not know. You give the are you mentioning upon notice?
There is a direction to serve. Affidavit is submit. I don't know. Who is
The-
appearing?
The difficulty is that direction to serve.
Yes,
Suppose you are the
Ma'am.
respondent's or opposite party's
Ma'am.
advocate.
Ma'am.
You have been served. Are you aware that the matter will come? Now it is a matter where he has to be also heard.
Yes.
Now if you mention it, what would have happened to you if you were on the other side? You would have been taken by surprise. Suddenly the matter appears. So why will you not give him a notice? Give a notice and mention. A list লিখে দেবে, no mentioning will be entertained without notice to the other side.
My lord, may I be permitted to mention
two CO applications, my lord. We have noticed the other side, my lord.
No, no. What notice? Where is
Notice
the
for
notice?
mentioning. My lord, it was supposed to be a joint mention, my lord, for final hearing, but he's stuck somewhere in traffic, my lord. But I had a word with the advocate, my lord.
See, hearing, I have enough hearing contested matters, I do not think.
But my
I
lord,
will be able-
may I ask for something, my lord? As per, I heard from the court official that this file is lying in Calcutta. This was taken by Justice Rai Chattopadhyay. It was ordered from Calcutta. So if that file could be at least brought out here.
এই ইয়েতে তোমার জলপাইগুড়ি ওখানে যখন প্রিন্সিপাল বেঞ্চে হচ্ছে আমাদের তো সঙ্গে সঙ্গে ডিরেকশন থাকে হচ্ছে ফাইলটাকে পাঠিয়ে দেওয়া, তো ফাইল আসে না কেন?
সার্কিট শুরু আর রোববার করে ওরা সব ফাইলগুলো আমাদের আমরা রিসিভ করি। এখন ফাইল এখন ওরা পাঠাচ্ছে না, কিন্তু আমরা
A CAN is also pending, my lord, the stay application. Subject to this.
নেটে দিয়ে দেয় যে কোন কোন ফাইলগুলো আছে।
নাও রিকুইজিশন পাঠিয়ে দাও, কিন্তু পাঠালেও তোমার আস্তে আস্তে সার্কিট ওভার।
My lord, at least the requisition, if that could be sent, my lord.
এরকম তো অটোমেটিক চলে আসে।
রিকুইজিশন পাঠাও। Is there any interim order passed in your matter?
Yes, my lord, an interim stay order has been passed, and as because that is lying in Calcutta, that stay order also has been vacated, my lord. That is the problem right now, my lord. And there is no change in circumstances. They haven't filed the affidavit of service as they had prayed for.
Very well.
My
Well, may I finish? May, under the very peculiar circumstances, my lord, I am mentioning, and your lordship will see all the matters are peculiar, but very, very serious in nature, my lord. What happened? My lord, give me a 1 minute, my lord. I have purchased a land, agricultural land. My lord, after subsequent of such purchase, my lord, I came to know that my predecessor interest had obtained a financial assistance from a bank. My lord, if it is a, my lord, the agricultural land, then the under the no financial assistance can be granted, my lord. Then, my lord, when the proceeding has been initiated before the DRT, my lord, against my predecessor interest, then, my lord, I have intervened, my lord. I said I filed an application. Then, my lord, my application was rejected. Then I went before the DRTA, my lord.
DRAT.
Sorry, my lord, DRAT, sorry, my lord. And DRAT, in a very wide, expressive manner, remanded back to the DRT, my lord, Siliguri, saying these are the points DRT did not consider. And these are the points to be considered. My lord, on the basis of the financial assistance of granted on the basis of a forged document. Because it was still the RTI and still my record says it is a Rupni. The classification of the land is, my lord, the agricultural. And I am the farmer. I am doing the agricultural purpose as on date, my lord. So, my lord, what happened thereafter? When it is remanded back, DRT did not appoint a commissioner. DRT, on the basis of the available documents placed before the court, considered, and my application was rejected. So the sale proceed was, my lord, upheld by the DRT in the month of December, my lord, 2024. That was on 17th.
The property has been put to sale.
My lord, it was initially. Then I have intervened. Then it was stayed. Then DRAT. Then again, my lord, sent back. Then this is the situation, my lord. So, my lord, now in December that order was passed. In January, my lord, after the, my lord, the vacation, I filed before the DRAT, my lord. The matter, as they filed the caveat, no interim order could be obtained, my lord. In the meantime, what happened, my lord? The honorable bench is lying vacant, my lord. Till May, I do not know anything, my lord. Yesterday, my lord, at the afternoon, my lord, with a huge police forces, the land which I am cultivating, my lord, that had been positioned, they have intended to take up position, my lord. And, my lord, what happened, my lord? Then I came to know a section 14 application filed by the bank, my lord. Then I have obtained a copy from the, my lord, the police officers. Then, my lord, the said order which has been passed by the, my lord, the land SCGM, my lord, Siliguri, which, my lord, said in the affidavit by the bank officer that no proceeding is pending, my lord. Is a completely the perjury, fraud upon the court, yeah. Even in the same section 14 application, we have not made a party. When I have filed an application, I made a party to the bank, I made a party to the previous interest. Before the appellate authority, I made matter remanded back. It is all in the knowledge, In these circumstances, my humble prayer before your lordship, may I be permitted to file without the certified copy, and kindly take up, my application,
Can't be helped.
Come.
Can't be helped. You are fire. You are coming against what?
I am coming in an application under 227 If this I understand your lordship's query.
You are challenging which order?
I am challenging the bank's action by an order of section invoking section 14 before the learned ACGM. Now, the section 14, your lordship.
Can it be in
I will satisfy your lordship.
Can it be under 227?
Yes, I will.
Under 226.
No, not 227, Why, If
Because
there is a gross miscarriage of justice.
If it is a action without jurisdiction.
No, jurisdiction he has. Definitely either the district magistrate or the CMM under section 14. CMM means the CGM or ACGM, no doubt. But the question is that, when the matter is in seizing, because kindly appreciate one thing, 14 application arises in view of 13.4, So, 13.4 application is in the seizing by the division majority of the DRT.
Basically, if you look into the scheme of the matter, one, you purchased a property. At the time of purchase, you did not see or you did not find
Yes,
that it was
equitable mortgage has been created. Yes,
Now, equitable mortgage has to be created by a memorandum and deposit of title.
Yes, my lord.
Then how did you get the original title to it?
My lord, on the basis of the certified copy, my previous interest said that the original document is, my fault. I understand, today kindly visualize, I understand. I made a wrong. But I am a bona fide purchaser, I paid to the person previously interest who has having a title and interest over the property. I paid. Now the deed of conveyance has been executed, Now, I am possessing, I am running, I am enjoying my property. Today what happened, kindly visualize. All the applications pending before the DRT, even the appellate authority. If the position has been taken, and if it is, the remedy is, my right to, address before the court, my audience, has gone, with regards to that, This is, the aggravation, 227 application, I understand, lordship, the 14, if there is a 14, then section 17 will follow. Absolutely, I have made a little research. I know lordship's query may come from your lordship's end. So,
section 70 language is very clear.
Yes.
Party or interested.
Yes,
Anybody interested.
Yes,
So that will take you into the fold of section 70. Now today, the only option which supports you is that the DRT still vacant?
Yes, my lord. May's order, and kindly appreciate one thing, your lordship know the L. Chandra Kumar judgment, Alternative efficacious remedy cannot be an absolute bar,
See, Mr. Chaudhuri, you are citing L. Chandra Kumar.
You will cite 24.
I will give you
24, I know.
Roger Matthews, Samuel.
Yes. But kindly appreciate one thing. True. This has been the questions laid down by the Honorable Supreme Court or various High Courts even, But kindly understand, kindly put me in my position, Kindly see that today where my remedies lie, where I will go, If my position has been taken with all police force, the ACGM, when acting,
What can I do?
If your lordship accept,
What can I do?
Yes, kindly.
If you have not taken assistance of the exact provision of law, what can I do?
Not exact.
I will checked into the Supreme Court, the Code of Civil Procedure.
Kindly.
What properties can be attached?
What property can be attached?
Which properties can be attached?
Property can be attached. There should be a secured asset. My lordship. No, that I'm saying, because the property subsidy will not come in. My lord, my lord, I understand, I will satisfy all query, my lord. Even these, my lord, these point even I will, my lord, satisfy, my lord. Property attachment. Suppose.
B.
Tools of or assist artisans, and where the judgment debtor is an agriculturist, his implements of husbandry and such cattle and speed grain as may, in the opinion court, be necessary to enable him to earn his livelihood as such, and such portion of agricultural produce or any class of
Agricultural produce. If you have a growing crop over there,
yes, I have a growing crop, my lord.
can it be attached?
No, my lord. So this is I have, my lord, the photographs, my lord. Still till, my lord, yesterday, my lord. I am the agriculturist, and I am doing, my lord, agricultural activities, my lord. So under, my lord, kindly take up, my lord, this my application. Otherwise, there will be remediless, my lord, at this juncture, my lord.
You file it. Have you filed it?
My lord, with the leave, my lord, with the certified copy.
Certified copy, which? Oh,
The order of the section 14.
section 14.
That I think.
Very well.
It's a huge answer. Proceeding, my lord, grateful, my lord.
ওটা দিয়ে দাও ইয়েতে এন্ডোর্স করে দাও
My lord,
But have you got a copy of the order?
yes, my lord.
Who is on your other side?
My lord, other should be bank,
Which bank?
Indian Bank, Allahabad Bank, formerly Allahabad, now Indian Bank.
Which branch?
Siliguri, my lord.
Give them notice.
Then, my lord, kindly take, my lord, I have difficulties, but still I will stay back for my client tomorrow, my lord. Kindly talk, my lord. I'll do everything, my lord. I'll do everything, my lord.
ওটা tomorrow I don't think it will be
My lord,
possible.
kindly, my lord, I will satisfy, my lord. Kindly appreciate my difficulties, my lord. Even my client's perspective, my lord. Otherwise, I wouldn't have, my lord, in such a manner. I beseech your lord, my lord.
দাও ইয়ে দিয়ে দাও
একটু কালকে টপে রেখে দিন আমার কালকে। হ্যাঁ, থ্যাংক ইউ, গ্রেটফুল।
ওটা ইয়ে দিয়ে দাও এন্ডোর্স করে দাও পেছনে হ্যাঁ
Leave to file.
লিভ টু ফাইল
My lord, I will serve in course of the day with an intention that matter will appear tomorrow. Grateful, my lord, grateful, much of.
I permit to mention, your lordship, one civil matter is there, CO 2024, the motions still. It's actually, your lordship, last it was the order passed by Ajay Kumar Mukherjee, 12/3/2025, মানে 12/3/2025. I couldn't able to find the current status in online mode, and instruction properly was not given. The urgency right now I will not be able to convey, your lordship.
What? I cannot.
Civil matter, CO 219.
I am taking civil matter while I am single. I am not taking any other matter.
Yes, sir. It's a motion.
Why are you mentioning it? This is not clear to me.
Yes, actually, instruction was not given. It's a motion matter, urgent matter. That's why.
Motion matter, urgent matter.
Yes.
Now, what is the urgency?
Urgency, the instruction was not given properly, that's the problem.
Instruction was not given. What has happened to the matter? You check, you take inspection of the file, you do. In this manner, don't waste your good time and the court's good time. You do not know ABCD of the matter.
yes.
You are coming and mentioning, what will I do? I am not clear what you are asking for. Whether you are asking for inclusion, whether you are asking
In the
for.
list, for inclusion in the list.
So if there is a, see, what I can gather from your submission,
Yes.
proper instruction was not given, so may have been an order has been passed against the interest of your client. Have you taken out any application? I do not know.
Even
You look into it, mention it tomorrow.
There is item number 1, a civil motion.
But what I'm appealing for the petitioner husband, my lord, I have filed this application under section, my lord, against the order filed against the order under section 24 of the Hindu marriage. Now, my lord, what happened, my lord, that the mutually divorce has been done between the parties. And my lord, he is not willing to proceed with the case, lordship. All terms and conditions have been settled, lordship.
So you challenge the maintenance pendentility order.
Yes.
Now
your worship.
today you are no more interested to
No,
proceed.
interested, I have the instruction, lordship.
And because there has been subsequent to this application, mutual divorce has been. When did you get the mutual divorce?
My lord, yes, my lord, the divorce lordship, just now, my lord, he has sent me over the, my lord, phone lordship. Yes,
Take down, take down.
my lord, divorce, my lord, that has been on
This revisional application has been
March
has been
2025.
filed by the wife challenging the order under section 24 of the Hindu Marriage Act 1955. During the pendency of the civil, during the pendency of this application, the petitioner, bracket a wife, and the opposite party, bracket a husband, obtained an order of dissolution of marriage by mutual consent on
My lord, on 6th March 2020.
on 6th March 2024. MS Swanso, on behalf of the petitioner, submits that the petitioner is no more interested to proceed with this revisional application. An instruction received by the learned advocate from her client is placed before the court, which is taken on record. In the aforesaid facts and circumstances, the revisional application, in the aforesaid facts and circumstances, the revisional application is dismissed for non-prosecution. Interim order, if any, stands completed.
Grateful.
Item number 2. Item number 2.
এটা কালকেও কেউ জানায়নি। This is the second consecutive day when no one appears in support of this application. এটা এবার ফাইটটা দাও।
Lord, item number 2, Mr. Ghosh should be appearing. He's in his legs in court number 3, my lord.
Sorry,
I will short pass over.
sorry. Has it become a practice of the day? Yesterday also no one appeared. Today no one is there. And when I am dictating the order to dismiss the application, you come jumping and say so and so is appearing. Don't try these tricks with me. Too old a campaigner. I am passing it off. After 5 minutes, it will be taken up. Let him be in other courts.
Item number 3 as well, ma'am.
Item number 3.
পাস ওভার করো 10 মিনিট পরে 5-10 মিনিট পরে ডাকবে আবার
Item number 4.
আইটেম নাম্বার 4 কালকে ডাক হয়েছিল তো ওই
Second one.
no one appears on behalf of the in support of the application. এই ফাইলটা দাও yes
Item number,
yes
item number 3.
কি বলবেন?
This is the second consecutive day when no one appears in support of the other.
It also appears that the matter was taken up on 7th April 2025 when the same was adjourned because none of the parties were present. On a perusal of the application, it appears that the opposite party, being the husband of the petitioner, has made an application under section 6 of the Hindu Minority and Guardianship Act, 1956, read with section 25 of the Guardian and Wards Act, 1890, which is registered as Act Roman 8, case number 29 of 2024. হ্যাঁ, এটা প্যারাগ্রাফ 2 তে দেওয়া আছে, ঠিক আছে? This application is pending before the learned district judge at Darjeeling. On a further perusal of the petition, it appears that the husband and wife are also from the district Darjeeling, and as such, the district judge at Darjeeling, and as such, the district court, and as such, the court of the district judge at Darjeeling is the competent court to hear out the said application. The petitioner says that since she is staying at Siliguri at her parental abode, it is difficult for her to attend the court of learned district judge Darjeeling to defend and or prosecute the matter. The petitioner therefore has asked for transfer of the said, ওই কি কেস নম্বরটা বললো?
Act of
হ্যাঁ,
18 or 2000.
হ্যাঁ,
Act of
to the court of learned additional district judge at Siliguri, district Darjeeling. Since no one appears on behalf of the petitioner, I have no other option but to, since no one appears on behalf of the petitioner for the second consecutive day, and that the matter had already been adjourned on 7th April 2025, I have no other option but to dismiss his application. However, dismissal of this application will not stand in the way of the learned district judge Darjeeling in transferring the case number such and such to the court of additional district judge, Siliguri. If the learned district judge so deems fit and proper. Let a copy of this order be communicated to the registry. Communicated by the registry of this circuit bench to the Court of Learned District Judge at Darjeeling. We see you such and such, accordingly.
Or any order.
Dismissed, disposed of, not dismissed.
Mother, I am applying for the respondent husband.
On the last occasion, this revision application was admitted and there was a direction to serve the respondent.
Yes, what is your prayer?
My lords, there has been a stay that has been granted at page 58. But no arrears of payment has been made in terms of the section 12 of domestic violence.
Yes, I couldn't.
Lords, I am the wife.
Yes.
And the husband hasn't made any payment. And lords, they filed an appeal. My lords, at page 58, they will find, my lords will find there is an order that has been passed wherein stay has been granted. Subject to
Stay has been granted by whom?
by the appellate court, my lords, in favor of the husband.
Yes.
Subject to a monthly payment of 15,000 rupees. But there is no finding with respect to the arrears. The reason I say so, my lords, is because this maintenance application, my lords, was filed in the year 2012 and it was disposed on in 2024. So for 12 years, my lords, there had been arrears that has accumulated. There was no direction.
No, it clearly says Rajnish versus Neha.
Yes,
It says from the date of the application. The date of the application, it has to be granted.
So when the stay was granted, my lords, what
So what did you do over there? You did not point it out to the court.
Yes, one thing. His civil petition has arisen from the proceeding under domestic violence.
Yes.
No, civil petitions, my humble submissions.
Maintainability.
It will be guided by the criminal procedure code. So,
Absolutely correct. Absolutely.
this will
But
not be the civil petition, but the criminal revision.
end of the day, why will you not pay the area?
My lord, lordship, kindly bear me for a moment. My lord, I am submitting the background of the case. Initially, a domestic violence case was initiated by the wife. Thereafter, my lord, the order passed. She was not satisfied with the order. She filed a revisional application. Thereafter, the revisional application enhanced the amount. Yes, enhance the amount. My lord, challenging that, my lord, two appeal has been filed, one by the wife because the wife is still not satisfied, one appeal by the wife, one appeal by the husband under section 29 of the domestic violence act before the London district and section 10. Now, my lord, husband's appeal was dismissed, wife's appeal has been entertained with
Further in enhancement.
enhancement. Now, my lord, the husband, my lord, filed two revisional applications before the Honorable Court, Honorable High Court. One is against the order of his dismissal, another is against the order of the wife's enhancement. Now, like these two criminal revisional applications were taken analogously, and that has been sent to the learned magistrate for reconsiderations on the basis of the judgment of the Rajneesh versus Neha, and to direct both the parties to file the assets and liability in the form of affidavit. Now, the wife filed the assets and liability in the form of affidavit, suppressing the fact that she is the only daughter of his father, and the father died, and she has inherited all the landed property, everything that has not been there in the.
Madam, what is the law?
Now, I'm coming, Lordship. I'm
No,
coming.
please don't
On-
beat up. Please
My-
don't
one
beat up.
more-
Please don't beat about the bush. The object of this maintenance has always been, whether it is Rajneesh versus Neha or the previous judgments, that you have to keep your wife in a befitting condition as of that of yours.
Yes, Your
Wife may have.
Well, it's not denied, Lordship. He has filed another proceeding.
What does your client do?
My lord is a school teacher. My lord, the wife, my lord, she has filed another application under section
Teacher-
125
teacher-
of the criminal procedure.
School teacher, how? School teacher in a secondary.
Secondary school. Now, my lord, in the 125 proceeding, my lord, the husband is paying 9,000. And in this proceeding, my lord, in my lord, the domestic violence proceeding, which has come back from the honorable court, there is a direction to pay 15,000. Lordship kindly comes to the impugned order, but according to my learned friend, that is
If I have correctly understood Rajneesh versus Neha, then there is a paragraph which says that if maintenance have been awarded by different courts, then the end result has to be taken. So 125 you are paying 9,000. Have you paid 9,000? Since when you are paying?
the order, Lordship, I am paying 9,000.
Since the order.
Yes, your Lordship. Since the
Well,
order, I am paying 9,000. And my lord, here I am paying 15,000 as per the directions of the learned magistrate. My lord, in the domestic violence, in the proceeding which has come back from the honorable high court.
So is it your case that you are paying 15 plus 9?
15 plus 9, yes, your Lordship. Now, Lordship comes to the impugned order, page 58. How it is impugned, Lordships, I am reading. Lordship, I am reading. It has been seen there is a possibility of succeeding the appeal by the appellant, but this is an appeal against the order of maintenance under section 12 of Protection of Women of Domestic Violence Act 2005. In such fact, without directing the appellant to pay the respondent, no order of stay can be granted. Therefore, the appellant is directed to pay a sum of rupees 15,000 per month as interim relief to the respondents for maintenance as well as alternative accommodations within 10 days of each succeeding months on payment of this amount. Let there be an order of stay. So, he is paying this along with that 9,000 in a 125 proceeding. Now, my lord, Rajneesh.
Where is the record?
My lord, today only, my lord, I have got this. My lord, I will bring all the records, Lordship. Because when Rajneesh versus Neha says, my lord, the husband, my lord, has not to be pay, my lord has not to pay, my lord, to the wife or to any of the dependents, my lord, in a multiple proceeding.
That is what I am
Yes.
saying. I asked you that question. Are you paying 15 plus 9?
Even then he is paying 9,000 in a maintenance.
9,000 was directed to be. Is there any children?
There is a child.
There is a child. So what was the maintenance sought for by the wife for her and the minor child?
The matter is still pending before
Matter, leave your side. Matter is pending. Don't play that long playing cassette. Matter is pending. Matter is pending. I am asking you a question. You please answer it. What was the initial prayer in 125 application for the wife and the child, or it was only for the wife?
That will.
For the wife and the child.
Huh?
For the wife and the child, and plus the amount of 15,000, I'm sorry to so much.
No, just a minute, just a minute. I will come to you. I will come to you.
That 15,000 has
let-
not been paid. Milord.
Let the steam of a submission go out. Then I will hear you.
So, my lord, that 125 proceeding initially, my lord, that was enhanced in 127 proceeding. That is also challenged by the husband before the Honorable High Court by filing a revisional application. And thereafter, he is paying 9,000 as per the direction. So, my lord,
So, every order you will challenge, the matter will be pending, and he will say that I am not. Very well. Very well. Now
that
I have heard you. Yes.
Plus this amount of 15,000 was
No,
my
no.
instruction has not
Initially
been paid.
9,000.
There is
was-
default on the payment of 9,000 also, and this 15,000
No.
has never been paid.
9,000 was directed to be paid for the child and the wife, or only
For the child and the
for the child and the wife. And 15,000 has been directed to be paid.
15,000 is directed to be paid by the appellate court, subject to the stay. It says that for the time being, till the matter is resolved, let 15,000 be paid. Even that amount has not been paid. Milord. And there is area from 2016 onwards.
But how do you come before 227 code?
Oh, no, Milord. Because this is an order under section 12, there are judgments says that it is quasi civil in nature, and therefore civil division will lie.
So,
I will come up.
my lord, I have also the judgment where my lord, the criminal revision will lie. And my lord, the act is very clear in section 28 where it has been stated, save and otherwise provided in this act. All proceedings under section 12, 18, 19, 20, 21, 22 and 23 and offences under section 31 shall be governed by the provisions of the Code of Criminal Procedure. My lord, the act itself is very clear.
On the maintainability of the civil division, Lords, I will satisfy my wish. Can be kept tomorrow. There are judgments.
Day after tomorrow, because I will take instruction, Lord.
Let her come up with the instruction of the payments that has been made.
I'll do as. But before that, Lordship, kindly consider the maintainability point, Lordship.
this is an application by the wife alleging default on the part of the husband to pay the maintenance as directed by the court first. It appears from the initial submissions made by the parties that initially a maintenance case under section 125 of the Code of Criminal Procedure 1973, in short CRPC, was filed by the wife, bracketed petitioner, for inter alia claiming maintenance for herself and the minor child. The learned magistrate had allowed allowed certain quantum as
The
maintenance.
learned session judge, I'm sorry.
Learned the learned district and session judge. Which
Mathavanga, Coach Vihar.
Additional Session Judge Mathavanga Kuch Bihar.
Mathavanga Kuch Bihar, additional session judge Mathavanga Kuch Bihar allowed the maintenance.
Allowed the stay of the proceeding subject to payment of 15,000.
No. 125 case. I am asking for 128. ওটা 128 ম্যাজিস্ট্রেটের কাছে which magistrate there the judicial magistrate Mathavanga had directed certain quantum of money as maintenance poster. Ultimately in an application under section 127 of CRPC, the quantum was enhanced and a sum of rupees 9,000 was directed to be paid to the wife on account of maintenance for herself and the minor child. Subsequently, in the
Page 58 minutes is the order in period.
yes, page
58 minutes.
now this criminal appeal arose from which order?
Section 12.
My lord, order dated 19/9/2023. It's the annex for it.
Which page? Which page?
Of ACJ and Matrimonial. কত নাম্বার থেকে annex করা? 19/9/23
18.
কি বললাম? Subsequently, the wife bracket petitioner filed an application under section 12 of the Protection of Women from Domestic Violence Act 2005. In short, D(V) Act. In the said application, where is that
Page
order?
29 is the relevant portion minutes. 2929.
29.
And in minutes, point number 4 minutes, the ideas were directed to be paid at page 30.
কি বললাম তোমাকে?
Their application.
The additional chief judicial magistrate Matabhanga, Coachbihar, passed an order on 19 September 2023 directing inter alia directed to provide a sum of rupees 5,000 per month apart from the maintenance amount as rent for alternate accommodation of the petitioner. কি বলেছিল ওটা দেখে নি, ওটা হচ্ছে পেজ 29 আর 2 clause 2 is directed to provide a sum of rupees here apart from maintenance amount as rent for alternative accommodation. ঠিক আছে? A sum of rupees 10,000 per month each for maintenance of the petitioner and her minor son was also directed to be paid by 10th day of English calendar month from the date of filing of the case. A direction was also given for payment of the arrear maintenance amount in both cases as per the order oblique judgment passed. In both cases within 3 months from the date of passing of this passing of the said order. The opposite party bracket a husband challenged this order by filing an appeal before the court of the additional sessions judge. Yes.
Page 59 is the appeal. Lordship will
Yes.
get everything from the page 59.
Sessions judge, third court, Kuch Bihar. Post.
No, Lordship.
Matha
Lordship. That is in respect of the earlier, my lord. Earlier, my
It's
lord. Lordship
58.
kindly comes to page 59.
No, this is what order?
This is the order which was challenged before the Honorable High Court.
Yes,
There are
yes.
2 appeals by the wife, by the
Page
husband.
58 is the order below.
Page
Says right.
59 is the appeal, my lord. Of this order.
কি বললাম? Additional
This order by filing an appeal before the
learned additional district judge, Matabhang, being Miss Appeal case number 1 of 2024. Full stop. The said appeal was dismissed by an order by
No, it was not dismissed.
It is not.
But
dismissed.
page 58 is the order.
The impugned order has been passed according to.
Page 58 will say the order.
I have read the one appeal has been dismissed and the order of the
Oh, that is the previous
That is the earlier one, Lordship. My lord, that appeal was made earlier by the wife, by the husband. Husband's appeal was dismissed. Wife's appeal was entertained from which.
Before my lordship knows, page 58 is the order impugned.
Yes, from those 2 orders, my lord, 2 criminal revisions by the husband before the Honorable Court remanded back. Thereafter this, my lord, again, my lord, the order of the learned magistrate in section 12 of the Domestic Violence Act, from which this appeal has been, my lord, arises, my lord. This criminal appeal
no.
number 1 of 2024.
in the order of the CRM remanded back the case.
Yes.
Now on remand, this order of 50,000
1,000 passed.
তাহলে বলতে হবে তো। এগুলো কোথাও তো পিটিশনে এইসব লেখেই নি, মুশকিলটা তো সেইখানেই না। পিটিশন টোটালি ব্ল্যাঙ্ক, এদিকে কাহিনীর পর কাহিনী হয়ে যাচ্ছে। হ্যাঁ, তোমাকে একটু আগে থেকে কি বললাম বলো?
The opposite party of the husband challenged this order by filing an appeal before the learned and his session said. Matavanga for.
No, no.
Miss appeal number.
No, no, this order was challenged. ঠিক আছে?
Miss appeal by 1 of 20.
So,
Page 58 it was.
now 19 September 2023, this order was against this, the husband and the wife preferred an appeal.
My lord, those two revisional application before the High Court was taken together.
The two revisional application before the High Court originated from which order?
Originated from that has been annexed, my lord.
Which
That has been annexed from two appeal.
Yes,
Page 31. তাই তো ঠিক বলছি তো, two appeal.
that is what I read.
Yes,
That is
revisional appeal
13 of
16
2016.
by the wife,
uh,
page 31, lordship.
so 19 September 23 order was challenged in two appeals.
No, lord.
Which order was challenged?
The page 31, lordship, kindly comes.
Yes. No, I am coming. No difficulty.
This order 28th of July 2013,
2018.
2018. And the same date, another appeal. Oh, 18th July, that's July.
Now, this criminal appeal arose from this appeal number 13 and 60 of 2016 arose from which order?
And from the order.
2016 order.
Yes, lordship will get it from the first paragraph. The instant appeal is initiated by the appellant being agreed by and dissatisfied with the impugned judgment dated 5/4/2016 passed by learned SCJ Mathamanga in connection with Miss TV case number 76 of 12.
তাহলে এখানে তোমার ওই জায়গায় কি বললাম বলো?
প্রথমে তো 125 এ
125 হলো, হ্যাঁ
আলটিমেটলি 127 এ এনহান্স করলে এখন।
হ্যাঁ, তারপরে
পার মান্থ ট্রিটমেন্ট চাই। তারপর আলটিমেটলি
হ্যাঁ,
অবলিগেশন অফ ফাইল অ্যাপ্লিকেশন 12 ডোমেস্টিক ভায়োলেন্স অ্যাক্ট।
না এটা হবে হ্যাঁ
ডোমেস্টিক ভায়োলেন্স অ্যাক্টে ফাইল করে
হ্যাঁ
সেখানে
ডোমেস্টিক ভায়োলেন্স সেকশন 12 ডোমেস্টিক ভায়োলেন্স অ্যাক্ট
19 সেপ্টেম্বর 2000
না 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 বিং ওখানে ওইটা কেটে করো বিং মিস ডিভি কেস নাম্বার 76 of 2012 Stop. This application was disposed of by an order dated judgment and order dated 5th April 2016 passed by the learned ACJM Matavanga. না ওটা না কেটে দাও, এটা নতুন করে দিচ্ছি, যাচ্ছি তারপরে, ঠিক আছে? না 27 এর পর ওই যে 127 এ হলো না, 127 এর পর এখন এই যেটা বলছি সেটা ঢুকবে। হ্যাঁ হ্যাঁ হ্যাঁ, ওটা যেটা এক্ষুনি বললাম ওর আগের একটা প্যারাগ্রাফ দিয়েছি দেখো। না 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 ওটা কে ইয়েতে ওখানে ইয়ে করো, তারপরে ওখানে করো দি এবারে নতুন ফ্রেশ ডিকটেশন নাও। দি পিটিশনার ব্র্যাকেট ওয়াইফ filed an application under section 12 of Domestic Violence Act, protection of 2005, in short DV Act, before the court of the learned additional chief judicial magistrate Matavanga being Miss DV case number 76 of 2012. Full stop. This application was disposed of by the learned ACJ Matavanga by a judgment and order dated 5th April 2016. Full stop. Two appeals were filed against the said order, one by the husband, bracket opposite party, and the other by the wife, bracket petitioner. The two appeals were disposed of the
These two appeals.
no, the two appeals, sir. The criminal appeal, huh?
These two appeals were disposed of.
এটা কেটে দাও। The criminal appeal being number 13 of 2016 filed by the petitioner, bracket wife, was allowed by modifying the order of the ACJ. While the appeal preferred by the husband was dismissed. Full stop.
2016, that is 15 of 2016.
Being criminal appeal number 15 of 2016 was dismissed. Yes. Two revisional applications were filed by the opposite party, bracket husband, challenging the orders passed in the aforesaid two appeals. Full stop. By filing two separate revisional applications before this court. The revisional applications, the said two revisional applications were heard together and disposed of by an order dated
12/12/2022.
12th December 2022 by remanding the matter to the learned ACJ Matavanga for fresh consideration.
With my lord, the assets and liabilities.
For fresh consideration, fresh consideration as directed by the said order. On remand, এবারে হচ্ছে
Now, Lordship, page 18.
yes, on remand, the ACJ Matavanga disposed of the application under section 12 DV Act, being Miss DV case number 26 of 2012.
76, Lordship.
76 of 2012 by a judgment and order dated 19 September 2023. সেখানে যেটা কাটলে না ওই পার্টটা বসানো হবে, ওই দুটো রেন্ট। হ্যাঁ, ঠিক আছে। Challenging the said order the
59 now.
the the opposite party, bracket a husband, preferred an appeal being criminal appeal case number 1 of 2024. The said appeal was
Fifty-eight is the
58 is the order.
impugned order.
yes. কি বললাম the
Challenging the said order, the husband opposite party of the.
criminal appeal, full stop.
1 of 2024.
In the said criminal appeal, on 5th January 2025, an order was passed.
3rd January.
3rd January 2025, an order was passed directing the appellant, bracket a opposite party dash husband, to pay a sum of rupees 15,000 per month as interim relief to the wife and the minor children for minor child for maintenance, as well as for alternative accommodation within 10th day of every succeeding month. Full stop. On payment of the said amount, the order of payment of the proceedings before the ACJM, Matabhanga being Miss DV case number 76 of 2012 shall remain state. Full stop. It is the case of the petitioner, bracket a wife, that the husband, bracket opposite party, has not paid the maintenance as directed, and as such, the stay of proceedings granted.
Has not paid the maintenance as well as arrears.
Maintenance and arrears
As directed.
as
As directed.
as directed.
And as such, we said.
Stay of the
Proceeding.
DV proceedings should be vacated.
Released.
Vacated. Full stop. The opposite party has objected to the maintainability of the revisional application by citing the provisions of section
28 of the domestic violence.
28 of DV Act. Full stop. It is submitted that only a criminal revision can be filed against the said order.
It's not about impugned order passed by the additional session judge law.
A criminal revision can only be filed and no civil revision lies against the order. It is further submitted by the husband that he has been duly paying the maintenance and there is no default. in making payment thereof. Full stop.
Along with the amount is the 127.
কি বললাম না এরিয়ান না
There is no difference in making payment there.
make a full stop. In the aforesaid facts and circumstances on the prayer of the parties না না ওখানে দেখো ওই ওটার আগে একটা দাও সেটা হচ্ছে the on behalf of the petitioner it is however submitted that the civil divisional application is maintainable. In the
And the
efforts,
payment is disputed.
maintainable and the submission made in respect of payment of maintenance by the husband is also disputed. Full stop. In the aforesaid facts and circumstances, let this matter appear on
Friday, no. The husband will come, my lord, with all
Friday,
the
brother.
documents.
all favor, full stop. On the next day, the husband, the opposite party, bracket husband, shall provide the details as to how and when he has paid the maintenance in compliance, paid the maintenance and the areas in compliance of the orders passed from time to time. Full stop.
But before that, lordship, the maintenance point.
First you satisfy me, I want to see.
My lord, the maintainability point to be.
We will argue it.
It's a very clear provision is there, my lord, the no.
See,
Criminal review.
I will definitely hear out the maintainability point, but you have to furnish the details.
My lord, he is paying, but my lord, as far as.
I want the details.
Lord, lord, my lord,
Without the details, I will not hear the maintainability.
lord, lord,
I'm deep.
grateful. Lord.
ওই পাসওভার ম্যাটার দুটো ডাকো তো এসছে কিনা দেখো তো।
Passover matter, item number 2.
In terms of the earlier direction, Millard, that there's a direction to file a supplementary affidavit that bringing on record a particular document.
I've seen that. Supplementary, লিখে রাখো, supplementary affidavit as directed filed in court is taken on record. Yes, who is on the other side?
No, it's still in the admission stage, it has not been admitted yet.
Really?
So that basically, Millard, this is against an order of the DRT. And that the order is patently perverse. That's why, Millard, we invoke the jurisdiction under Article 227, Millard, instead of preferring an appeal. Instead of preferring an appeal before the DRT.
But if it is without jurisdiction, then probably
I won't say without jurisdiction, Millard, it's perverse. The finding is patently perverse.
if it is perverse, then 227 or 226.
But 227 also, because Millard has the supervisory jurisdiction under. 227.
Maybe. But when you are attacking the order at its root,
Yes.
so perverse means to a great extent it is also without jurisdiction.
Without jurisdiction.
So in that case, it will be a writ petition, Mr. Ghosh. Because if you-
Millard is correct, Millard, but subject to
If you
correction.
look into the judgment of Justice S.B. Sinha, if I correctly remember, 2006, reported in AIR.
I will. Millard,
There
try
is
to
a
look at it.
difference between 226 and 227.
Yes, right,
It has been carved out.
right.
You look into it, because no point in deliberating it. আমার খাতাটা নিয়ে এসো তো একবার দেখি ও লেখা আছে কিনা ওটা। But 2006, I am sure.
Millard, I'll try to find. I am readily, Millard, I cannot recollect this. Millard.
Oh, if I have it, I will give you the without beating about the bush.
Millard,
Now-
this one line in the judgment which prohibits me from transferring any other properties which belongs to me. I am aggrieved by that. Because the property in respect of which the security interest was created by way of equitable mortgage, any recovery proceedings can subject that property, no difficulty. Now, we could also see the conduct of the bank. Mortgage was enforced.
See, two things. One, it operates as an order of attachment before judgment.
Yes.
Now, attachment before judgment, if you look into two judgments, one is 2012 probably, Sunil Kakrania, and the other is Kolingo Iron, delivered by the Division Bench of Justice Bhaskar Bhattacharya. Reported in CHN, I am sure. Now you will find there is a discussion in connection with Order 39-12, 38-5 in the context of Section 94. Because Section 94, you will see supplemental proceedings where attachment can be done. Now, there the discussion clearly holds that in case of a property which is being injuncted, attachment before judgment, normal reaction is, or normal right is, I am free to deal with my properties. Unless there is a specific decree against the same. I am entitled to enjoy the same. So, the property which is secured may, in view of the equitable mortgage or this security created under the Securitization Act, Surface Act, cannot be transferred. But the other properties, there cannot be an embargo, which you are saying, it is to an extent. I give you the relevant legal provisions also. So, in that situation, you may have a case, but in 227 or 226. Sunil Kakrania is 2012 1 CHN 86. So I give you that is 2012 1 CHN 86. Probably it is equivalent to 2012 Calcutta 26. Please look into it. And the other one is 2014 1 CLT 559 Kolingo. You also check 2013 for CLT 552 and 2012 for CHN 386. You check it, 2006.
I will.
Justice SBC, na,
Yes,
2006, it's reported in AIR.
I will.
Huh? Acha. When do, you can come tomorrow?
Tomorrow, or probably the day after tomorrow. I'll have a look at all the that.
Very well.
Day after.
Day after tomorrow, one. Huh? After the petitioner argument on behalf of the petitioner is commenced but could not be concluded. Let this matter appear day after tomorrow. ঠিক আছে? হ্যাঁ? কালকে তো পরশু দিন। Very good. The other Passover matter, this is 3.
This is 2.
3 and
also,
4.
Millard, I am appealing for the petition. Millard, this can come up tomorrow. Millard.
Very good. But be there, be
I
there.
will.
Be there.
Or it's been court number 3 minutes.
I do not dismiss the matter because ultimately it is the litigant who suffers, but continuous adjournment is also not permissible.
Definitely.
I'm mentioning it's for inclusion in the dissolution.
When did you file it? When did you file it? When did you file it? Was it listed before any other circuit? What was the direction over there? You are coming and mentioning. Because see, the difficulty is that when the circuit is not there, matters are moved in the principal bench. The file is not available over here. So that is the reason I'm asking you whether it was enlisted before any circuit bench, because then the file will be available. Otherwise, you mentioned it, we will be asking the requisition to be sent. The file may not reach. So you should come prepared with all these things. Tomorrow you come ready and mention it.
Item number 1, under bail in connection with appeal.
For the state,
Yes, for the state.
who is for the petitioner নেই petitioner নেই পাস ওভার করো এই একটু ঝামেলা ক্রিমিনাল ম্যাটার তুমি ডিসমিসও করতে পারবে না আর
Item number 2,
Shima, for the petitioner events, Shima Mandlas, she is appearing in virtual.
yes
May it please, Millets. As I beg to appear, Millets, for the petitioner, Millets.
yes who is appearing for the state?
Lordship, in this case, Mr. Arjun Chaudhary is appearing.
Ask him to be present.
Yes, Lordship.
May it please, Millets.
Yes.
Millets, this is a case, Millets, wherein Millets, the appellant has been erroneously convicted, Millets, under Section 6 of POCSO, and Millets, the sentence that is awarded is of 25 years.
Yes.
On the last occasion, Millets, we had shared, Millets, a small tabular chart for your lordships to demonstrate, Millets, the discrepancies in the case. Because this is a case, Millets, there is no eyewitness, there is no medical evidence. And even the name of the appellant, Millets, has only arisen as an afterthought. And Millets, there is material discrepancy between Millets, the 164 statement and the deposition in the court. So Millets, we have, Millets, in fact, jotted all of this down for your lordship's convenience. And I just have, Millets, just 3 documents to show your lordships for this. And then, Millets, we have 3 judgments of the Honorable Apex Court, Millets, which say that in cases of rape, Millets, DNA analysis, Millets, is the most crucial. Here, Millets, admittedly, there is no biological sample which is collected from the appellant, Millets. And Millets, so in the end, there is no Millets matching to show that at all there was any kind of intercourse with the appellant here in Millets. So if you just may be permitted to show your
Just interrupting.
Please, Millets.
From the date of complaint and from the arrest, what was the difference?
Millets, from the date, Millets, the date of the incident was somewhere in Feb 22. Even the prosecutrix does not remember the date. Then, Millets, the first instant is that the prosecutrix is taken to the hospital where it is alleged that she has incomplete abortion. So, in that case, Millets, there is an MLC, Millets, that is carried out. In the MLC, the appellant is not named. That MLC, Millets, forms the basis of the FIR. Even in the FIR, the appellant is not named. Appellant is, Millets, in the same military complex. He's just residing in the quarters opposite to the prosecutrix and her family, Millets. Thereafter, as an afterthought, after 3 days, Millets, it is that the name of the appellant pops up for the first time, and then he's arrested, Millets. And he's been in custody for over 3 years now. If I may be permitted to show this to your lordships.
Yes.
Millets, the MLC, Millets, is at page 87, Millets, or this is, Millets, CRAN 2. This is the suspension of sentence, Millets.
Page 80?
87, Millets.
এটা কি গো?
Millets, there are some of the documents, Millets, had to be given in sealed
The
cover.
FIR,
Name of the prosecutrix was there.
FIR, written complaint and other case records.
Copy of
admittedly by both the sides that rent is beyond the scope of the West Bengal Domestic Tenancy Act. This is admitted position by both the
Section
sides.
3, Section 3.
Section 3, double F.
What is the quantum of rent?
5170, 5,170. This is within the Darjeeling municipality.
So
Rent-
5,000.
5,000. So rent is 5,170. It is admitted by defendant also. Now, the only one question that has been raised by the court, lower court himself, that since the notice is captioned with the section 6(4), although with a clear finding that notice is legal, valid, and duly served upon the original tenant, but since the caption speaks about section 6(4), that's why the suit cannot be maintainable and suit has been dismissed. This is the only reason, my lord.
সার্ভিসটা হয়নি কোথায় চলে গেছে বলছে she has been shifted to another place hence unable to deliver.
But notice was served to the defendant number 1, 2, and 3. All these defendant 1, 2, 3, 4 presently they are the substitute defendant. The defendant number 4, for which the someone could not be served, she is the daughter of the original tenant. Original tenant died during pendency of the suit at least more than 6 years back.
He has right to defend.
Lordship, but on the same address, someone was served during the pendency of the suit, and she appeared by the advocate. Same advocate who represented the defendant number 1, 2, 3.
ওটাকে কবে রাখবে বলো? Next Tuesday, you will serve a notice.
Lordship.
কোন opinion appeal?
One direction was there to for depositing some cost. I have already paid the cost.
There is a delay.
No.
Delay has been condoned.
Yes, that has been condoned.
Huh?
Yes.
When it was condoned? Oh yes, got it. 5th January 2022. Okay.
Matter is otherwise ready. I will come back and by serving the copy. And I will take another attempt for service.
Yes.
Lordship.
Done. সামনের মঙ্গলবার
Grateful.
Yes, next.
16. Item number 16.
So I on behalf of the appellant, I led by Mr. Tapas Kumar Bhattacharya in this matter, Lordship. There is a direction to file opposition, Lordship, to the respondent, Lordship. Till date, no opposition has been filed, Lordship.
We have the opposition evidence. It's ready, my lord.
No copy has been served on the appellant, Lordship.
Sir, opposition to the application for condonation of delay.
Established.
So you file reply?
Yes, sir. I am applying for.
Affidavit in opposition to the application for condonation of delay filed on behalf of respondent number 2, 4, and 5, 2, 4, 5 and added respondents.
My lord.
It's taken on record. Stop. The copy of such affidavit in opposition has been handed over to the learned advocate representing the appellants. Acha, stop. Acha, the appellants pressed for leave to file affidavit in reply. Press for extension of time, naki?
No.
Press for leave to file affidavit in reply thereto. Stop. Leave is granted. Let such affidavit in reply be filed within 1 week from date. List the matter for further consideration.
Next week.
Eh?
Next week.
Next
Lordship.
next week কবে দেবে?
আজকে হচ্ছে 10 অনেক 18th
18th.
18th.
I am happy for this number 3, but I have not received the soft copy.
To serve.
Lordship, we have served Lordship, so far my instruction Lordship.
No, it has not been served.
Then Lordship, I will serve.
You served, you have to also, you have to serve.
No, I have served the copy of the affidavit in opposition.
Served upon respondent number 3.
I am, sir. Serving the copy.
Okay, you also serve.
Lordship.
আচ্ছা আমি ওইটা যেটা বললাম না যে copy of the such and such has been served upon the learned advocate repenting the appellant as well as the respondent number 3.
But copy of the appeal has got to be served.
ও তাহলে কেটে দিন ও পর ইউ as well as the কেটে দিয়ে you serve.
Lordship.
Okay, oral direction. Next.
Item number 15(1) in that I have already sent the paper book to all the defendants, and one paper book that has been returned back. It is I have submitted it in the service affidavit in service. So I don't have any other copy except this my.
Take back the affidavit of service. We have not recorded. We have not taken on record your affidavit of
May I
service.
send that
You take back. You serve. Cause another service and file affidavit service on the returnable date. Or affidavit service টা আমাকে ফেরত দিয়ে দিন তো। হ্যাঁ করে দিন তো নিয়ে আমরা রেকর্ডে।
But it has been made part of the evidence.
No, had not been made part of the record and hence it.
Not part of the record, but made part of the affidavit in service.
You take back, reaffirm. You reaffirmed it has not been taken on record, so you may reaffirm it, filed on the returnable date.
Item number 17.
Now for the respondent.
DSGI online, this matter is relating to arbitration, 37 appeal.
Yes.
Lordship, I would renew my earlier permit any day after Thursday.
No, this is an application under
37
appeal arising out of 34.
Lordship.
Now, what was the subject matter of the contract?
My lord, it was a building contract given by the Union of India.
Very well, Thursday.
My lord, Thursday, as your lordship pleases.
After Thursday onwards.
No, after Thursday, then Friday. We have kept one of your matters on Friday.
Friday, my lord, Friday, Monday, whatever lordship wishes.
Very well.
Friday,
Item number 18.
My lord, in item number 18, before the petitioner starts, I want to submit that I've been engaged, my lord, in this matter by the the respondent, my lord. But since they have served the copy of the paper book at Mumbai, the paper book is on its way, my lord. It has not reached me, even the Vaklatama.
It will not reach you.
My lord, it will
get a paper book from them.
No. They have already, it is in transit, my lord. Kindly keep it on Monday.
What is the matter about?
Even the honorable judge's copy, my lord, we could not file it because until it is endorsement of receipt is there, the department was not accepting. So,
What is the matter about?
it's like That appeal Millard against a dismissal of the suit. Dismissal
Order-
of a money suit.
Money.
Order 7, Rule 11.
No, 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 it's a final dismissal.
Final dismissal.
Upon evidence.
Ah.
It was dismissed Millard on the ground that the power of the constituted attorney was not empowered to depose. That was essentially the findings of the court. So Millard, my affidavit of service is there, they have already received, and since on the earlier occasions, no one appeared for the respondent, the honorable coordinate bench directed to serve it upon the respondent directly, the paper, which we have complied with.
Mr. Ghosh, in the warning list we find paper book intimation is given, it has been prepared, please come and collect. Now 2021 appeal paper book is not being collected, and 2024, 2023 appeals are ready for hearing, paper book made. This does not send a good signal of the part. If you are ready, collect the paper book. Because I tell you, I will definitely put these matters before I leave for this finishing this survey. If it is not collected and I find that it is still pending, that is not the proper way. Very well, Monday.
Diploma.
Item number 19.
Lordships, I am for the appellant.
Yes.
Lordship, we have just received the notice of arrival of the TCR. So kindly a period of 4 weeks be granted to prepare the paper book.
What is the appeal about?
The appeal is about the eviction, Lordship.
Eviction.
I am the landlord. Yes, your Lordship.
Your suit has been dismissed.
Yes, your Lordship.
On what ground? On what ground?
On what ground?
On
your
the ground of area, Lordship.
On the ground of
Area.
area.
area?
Maintainability, your lordship, I'm appearing on behalf of the respondents, your lordship, in this matter. So what had happened that the bank had was a tenant of the present appellants, your lordship.
Yes.
Subsequently, the appellants had taken a loan. So what they had insisted, your lordship, that instead of paying the tenancy, the bank can retain the place and the amount due for the loan amount.
Rent will be adjusted against
Yes,
the.
it was the contention of the appeal, which was subsequently dismissed, that it was not the terms of the loan or of the tenancy agreement, your lordship. So the learned civil judge senior division Siliguri had dismissed
Dismissed
their
the
claim,
suit.
your lordship. So they have come before your lordship for the appeal here.
No, but she says eviction. What is the eviction?
Eviction of the, so what had happened, your lordship, the bank had already left that place, your lordship, but they were not initially accepting the keys because they were of the terms that it can be adjusted. The amount they had taken, the mortgage, instead of giving the mortgage, your lordship, so they could retain the place, the bank could retain the place and continue, and without giving any mortgage, they had that from inception, they had that believe, your lordship, but it was not reflecting in either the loan agreement or in the tenancy.
How much amount is due and payable by you?
That has already been paid as per my instruction, your lordship. That has already been done on the part of the bank. We have already paid, your lordship.
And what amount is loan amount is what loan amount?
That instruction I need to take, your lordship. That I am not prepared with that details, your lordship. The particulars of the pecuniary.
Madam, the difficulty is that today they have already vacated the place.
Yes,
you have got the vacant place. Now,
Lordship, it's a money claim.
maybe a money claim. maybe a money claim. Today, is there any serious thing involved? Because see, you have, if they choose to not to stay, they cannot, you cannot compel them to stay. If I say that I won't be taking your premises on rent, can you compel me? You cannot compel me. But on the other hand, you had taken a loan, it is an admitted position. And for the loan amount, to secure the loan amount, you must have provided some security. You are trying to circumvent it, that the rent amount, you continue to remain in possession of the suit property. The rent amount should be adjusted against the EMI or the
Installment, yeah.
EMI or the
Loan.
installment. So that cannot be done in such a manner, because they don't require your premises.
And it has been vacated back in 4th of May 2016,
So
your
the
lordship.
prudent decision is that to save your property, you put someone in or put some tenant in and pay the rent receivable from the tenant to the bank, if you have any outstanding amount. Unnecessary appeal. Think it in a prudent manner, think it in a practical manner, in the commercial eye. Very well. We are keeping day after tomorrow we are keeping it. You come with the instructions.
Yes, your lordship.
Yes, your lordship.
Particulars of the outstanding balance and they have already vacated in back in 2016, your
Give the
lordship.
details.
Yes, your lordship. I will prepare.
And have you proceeded against them under securitization? Surface, you take that instruction also.
Yes, your lordship. I will. Grateful.
Grateful, lordship.
Item number 20.
My appeal, my lord. The mad appeal, my lord.
Who is your other side?
My lord, he doesn't bother to appeal even. If you see, reconciliation even was called on 3 consecutive occasions, and even the, my lord, the honorable division bench even had interfered for such reconciliation, he did not turn up. And this is the same thing, my lord. My mad appeal since a decade. I am the husband.
Frightened. Frightened by your omnipresence.
Oh, no, not because of that, my lord. So,
The additional advocate general appearing for the husband in a matrimonial, definitely definitely the wife is scared.
Yes, frightened, petrified. That would be proper.
What is the subject matter of appeal?
our subject matter is the desertion and cruelty.
Desertion and cruelty. You suffered a decree.
Yes.
No,
I because it was dismissed. My suit 13, it was dismissed, and 1 lakh rupees cost was even imposed.
Right.
That was stayed by the rightly by the honorable division bench. And my lord, kindly take up, my lord, or your lordship can fix it tomorrow. I will serve a notice again. I will take my.
The difficulty is that Mr. Chaudhary, you will appreciate, since she is a lady, she is entitled to legal aid. If no advocate comes, we cannot hear it out in
This is the reason, my lord, a chance. I can serve a notice to the learned advocate, my lord, to my learned junior. See, even my lord, if she chooses not to, my lord, then let us say that my advocate is not, then my legal aid assistance from this assistance can be given from a legal aid.
See, we do not adhere to the procedure. In this sort of cases, administrative notice is required to be served. administrative notice by the.
That is court, by court.
By court. You see, if we can contract, we are keeping it, say.
Then to my lord, my lordship can understand, my lord, this is a matrimonial discord. And neither nor she is staying happily, nor me even staying happy. And my son is even suffering.
That we are not going to.
No, that is the practical, my lord, the to some extent the difficulties, my lord. And these are the issues, my lord. Even personally, I have taken some efforts so that it can be a reconciliation can be made. But that also could not, my lord.
Hey.
And if you see the, my lord, after certain exhibits, the letter the wife written is not a love letter, my lord. This letter a constitutional state, my lord. They are all exhibited.
The law is very well settled. The only judgment we have in our support, in your support regarding mental cruelty is that Samar Ghosh. That is the pivotal one. Now, thereafter, see, Supreme Court under 142 had, I can tell you, I had lost a matter. I cited before a division bench, I cited, when I was in the bar, I cited the judgments that two aged couple who don't have any child, it is better to be
Live their life as they want to do.
In fact, there are judgments I can tell you, one by Justice Ruma Pal, then one by Justice Ranjana Desai, where two IAS officers were involved. But the division bench said no.
This is 142.
It's under 142. We cannot do. We will look into the matter in the context of
the records
and the evidence.
I'd like to invite your my lords to only within the four corners of the record, your lordship is see and will be happy that it is a fit case for granting a divorce under Section 30.
We will try to contact them because otherwise we have to send an administrative notice. Because otherwise it will be.
Then, my lord, today my junior, I am requesting the learned advocate. Matter will be appearing tomorrow.
In the district court.
No, my lord, he stays in Siliguri. He stays in Siliguri. He is also.
I don't think possible. You are coming back on Monday.
No, my lord, tomorrow, as your lordship fixed one matter, I have rescheduled my all things journey in the evening. So whole day I will be there. Then Thursday, Friday I will not be there.
So Monday,
then if the notice is required, then we'll have this circuit I will miss. And if your lordship see the previous order, the same.
Otherwise, in any event, you will miss this circuit because administrative notice 15 days time is required.
No, administrative notice will be gone. Today let us try. Let us try to today. Let us try for tomorrow. If not, Milord, then even it will be Monday. Let us try for that. Great.
মহিলা তো লিগেলে দিতেই হবে, লিগেলে দিতেই হবে। তাহলেও 1 মিনিটও যদি জিতেও যায় 1 মিনিট সাসপেন্ড করতে পারে।
সাসপেন্ড করা যায়। It cannot be suspended. These are the certain Milord, the matrimonial is no laws even.
See, this is such a branch where the less said is the better. Nowadays, young couples, what is the problem you will unable to understand? Only clash of egos.
That is the problem.
Because see, this is a
vis-a-vis
diluting
the institution,
diluting from the main context. This is a socio-economic problem. See, our society was at one point of time based on joint family structure, where during the marriage, the involvement of the family members of the bride and the groom was there. Then in case of any dispute, there was a question of reconciliation. There was situation of reconciliation by the
seniors, by the senior member of the family,
by interference. And the other thing,
Now to Milord, there is no
most of-
belongingness.
most of the bride and grooms were young aged. They did not have their own values or confirmed values. Now, if you say a lady aged about 30 years, she is coming from a different environment. Now, she has her own values, her own decision-making authority. Now, she may not compromise. At the same time, the husband also has his own values, own fixed views. He is not willing to compromise. The end result,
But
a soured relationship.
But my personal view, the parents are responsible.
Whatever may be.
What I have seen in all matters, either way, in-laws or the parents, they are responsible for this, for irreparable breakdown. Because the interference in some other way is very difficult. The previous interference was for the constructive purposes. Now the interference for destructive purposes is the difficulties.
So you cannot see the society is evolving in such a way. It's very difficult to even gauge or predict anything. So I said that less said is the better.
Yes. All grateful, Mal. Then tomorrow I'll take my chance. I'll issue notice to requesting the learned advocate to.
Your that other matter
Yes.
you obtained leave in the single bench.
Yes, Malad.
All illegible annexures.
Malad, I have made this efforts, Malad. Certified copy even Malad I have obtained. Even Malad, I will that will that's now I received the information from our trial court. So that will and these some Aadhaar cards and all, Malad, these are the some illegible, Malad, because your lordship can understand at night even I have worked till 2 AM and it was all sent through WhatsApp messages. And I have downloaded and this is the reason, Malad. Your lordship, I am very grateful, Malad. Your lordship has given me a leave so that I can address your lordship tomorrow. I'll rectify.
You check, you ask your junior to.
Yes, I will do that, Malad. I said already, but I'll do that after Malad report.
Will you?
Grateful.
Item number 21.
Lordship, I am for the appellant, my lord. Appearing virtually.
Yes.
Am I audible?
Yes.
My lord, there is a small mistake on our part, my lord, that we have prepared the paper book, we have served the opposite party also, my lord, but by mistake, my lord, my associate, she has taken the office copy with her and the original copy is with me, my lord. If your lordship may be kind enough to allow me to bring the original copy tomorrow, then I'll be very grateful, my lord. She already is present, my lord. She is holding both the copies. It's just that by mistake she has taken the office copy, my lord, and one of the original copies with me, my lord. And I was in Delhi, my lord. I was like, I only reached today, my lord. I really do apologize for my mistake.
What is the matter about?
The probate proceedings.
The matter.
Probate proceedings. What is the
Was it probate granted or probate refused?
Probate granted.
Probate granted, my lord.
In my favor, and he contested.
So, you are challenging a decree in a contentious probate proceedings.
My lord,
which has been marked as a testamentary suit.
Absolutely, absolutely, my lord.
What are the grounds of challenge?
My lord, the grounds of challenge are basically two, my lord. The first is the signature of of my father, my lord. All his life he has been signing in English, my lord. It is allegedly I am unable to procure the will because the will was not given to me.
This is not annexed in the paper. That has been another difficult.
My lord, I have gone to the department, my lord. The problem is
in the paper book.
Photo once.
So the will, yes, in the district court, after the will is filed separately. After it is exhibited and the case is over, it is kept in a separate safe custody in a separate manner. Unless that will is produced, no one can look into the will.
That is the biggest challenge in this matter, my lord.
Lower court report has been called for. I think the will also be produced before this.
My lord, no, my lord, it cannot be.
let us see এটা ইয়েকে ডিপার্টমেন্টকে জিজ্ঞেস করবে তো যে অরিজিনাল উইলটা এসছে কি
Will also.
No, my lord, if I may,
No,
my
no,
lord,
if we don't call for, they will not say anymore.
my lord, I
Yes.
have inquired
It
with the
is-
department.
The copy is with you.
Lordship, I am not.
You are the propounder.
I am the propounder at that.
So will is with you.
No, copy.
Copy of the will with you.
So.
Yes, my lord, the original will is replaced by a Xerox copy of it, and the Xerox from the Xerox cannot be given. That's why I could not procure the will, your lordship.
Maybe original copy has been kept by the court in safe custody, but the copy of with you, either with you or your with your learned friend, produce the same.
Because of when he challenged the matter, at the district court, therefore when filed the appeal, he must got the will.
You proved the will before the court.
Court.
So it was with you at the time of trial.
Absolutely.
And presentation of the petition also it is with you.
Yes, Lordship. That is the.
So copy is also with you.
Lordship, so far my instruction, I have not got the you kindly give me the.
My lord, I have inquired with the department, my lord. The original copy of the will is not with the department, my lord.
There is no.
Very well.
Lord, I am not given the will. How am I supposed to give the paper will in the paper book, my lord?
Another case I have been conducted in this. The will has been already been produced before this honorable court, and that is in a box.
My lord, it would require. It would.
So far, my knowledge is.
You come tomorrow. Let us see. Let us see. Come tomorrow. Let us see what happens.
As your lordship pleases. As your lordship pleases.
Lordship.
মামলা হবে না মামলা
Tomorrow he is in Delhi, most probably. Delhi.
না না এসে গেছে
No, I have arrived, my lord. I arrived yesterday night only, my lord.
Okay.
এখন রেস্ট নিচ্ছে
He contested the matter already.
এখন বাড়িতে রেস্ট নিচ্ছে আবার ছুটি করছে
No, sir. I am in my chamber, my lord.
You bring the copy.
Okay, I time it.
It is with you.
No, Lordship, now. Yes, it is fine. Lordship is correct. Absolutely correct. There will be. But so far,
Copy is with you.
Yes. When I because of the copy, when the certificate is will is there. But
my lord, my lord, one more thing, my lord. I was never given an opportunity to cross-examine the witnesses also. My lord, it is evident from the
yes,
depositions and the
you are not
cross-examination.
He is not appeared in the trial court.
No, my lord. It was ex parte, not against me, my lord. It should be. My lord,
look into it. Look into it.
I will prove it, my lord. I will prove it tomorrow, my lord. Yes.
Develop.
Item number 22.
Not
Much obliged.
Not today.
Lordship,
was appearing virtual.
I'm dealing with the matter. Today morning I went to court, but all of a sudden my due to my blood pressure fall down, I came back home. Lordship, may kindly raise the matter tomorrow. I'm requesting for a note today, kindly.
Hope your blood pressure.
Don't appear in this way. Tell your learned friend to pray for adjournment. You are appearing wearing a genji and such.
Lordship, I'm sorry, but actually Lordship is very much annoyed with the other adjourned matter. So
Supreme Court was annoyed. Supreme Court was annoyed when a learned advocate appeared.
My apology. I'm stopping my video. I'm stopping
appearing
my video.
in a court cannot be stated as a casual act or casual action.
Lordship, I agree, but the thing is, I was fallen tremendously sick. All of a sudden.
Tomorrow.
Grateful.
Item number 23.
Why? This is the difficulty. The bar complaints hearing matters are not being taken. Right from I have lost my interest. Right from the first matter hearing, everybody is seeking adjournment.
I'm further responding.
What is the matter about? Can you tell us? Or you are only engaged for adjournment?
I just joined the chamber.
Actually,
what is the matter?
Well, the applicant is a husband. Well, applicant is husband and is filed an application. Deferred the Learned court.
Applicant is the husband.
Husband, my lord. And the-
পাঁচটা application আছে।
Who has filed a
Suit
suit
for,
for
uh,
dissolution of marriage.
marriage in the ground of desertion and cruelty, my lord.
Yes.
And it was subsequently it was dismissed, and the learned court cost 5 lakhs to the husband, my lord, appellant.
Huh?
To the appellant, my lord.
আচ্ছা জীবনও হবে না এগুলো।
There are 5 applications.
ও সব ওই অ্যাপিলটাকে বাঁচিয়ে রাখতে হবে, সেই জন্যই অ্যাপ্লিকেশন ওয়ান আফটার দি আদার।
Last occasion, my lord, I pay for liberty to file supplementary affidavit, my lord.
What supplementary affidavit?
Because, my lord,
You are for the respondent.
Tell me, tell me in the appellate stage, where is the question of filing a supplementary affidavit?
Actually, my lord, what has happened, one criminal case is pending. A criminal case was, the wife filed a criminal case against the husband. And subsequently.
Whether it was considered by the trial court.
No, my lord.
So how you can?
The husband acquitted, my lord, in this proceeding. My lord, actually, the husband filed an application for bring the record of the lower court criminal proceeding, judgment of the criminal proceeding as additional evidence, my lord. So against that, I filed an opposition and said that the appeal is pending against the order. And subsequently, the appeal was withdrawn by the petitioner, by the wife, my lord, and filed again appeal. And this is I bring the record to before the honorable court that the fresh appeal is pending.
What does Evidence Act say? What does Evidence Act say? Are you required to seek for production of the document or certified copy of the evidence in a proceedings between the same parties? Because you are the de facto complainant.
I am de facto complainant.
There are provisions. Have you checked up the provisions of Evidence Act?
No, look, why though I am mentioned that the appeal is pending, the number is somewhat subsequently changed, so I take liberty.
এরকম কাঁচা অবস্থায় কি অ্যাপিল শুনবেন বলুন তো? তো নিজেই জানে না নিজের কেস কি। Come back, get yourself ready. This is not the way one is seeking for adjournment, the other knows very little about the matter. Not today, not today.
Item number 24. 24. 24, I am for the matter, criminal appeal, I am for the husband. Lordship, practicing and received the brief last on day after yesterday. Evening. Lordship, can you give me?
No, from whom did you receive the brief? How was the appeal filed? Who had filed the appeal?
And by the I haven't done even.
So where is that junior advocate? Where is that junior advocate?
So, Lordship, can I come on ask him to appear on the but Monday, it will Monday, I can.
You are very sure that Monday, if I start the hearing of a matrimonial appeal, by Friday I won't be able to complete it.
No. Small matter. Because of they are matrimonial, there is a two evidence.
Who is your junior in this matter? Devorshi Dhar. I told him that his name should be, he should file an affidavit and make his name Meghnad, because he is more vanishing than appearing. So Mr. Dhar had filed the appeal.
Yes.
Now today you are coming. You are briefed. You say you are briefed today.
No.
Now Mr. Dhar was briefed earlier. So ask Mr. Dhar to do the matter.
See this time. I see this.
Too old a campaigner of listening all these things. Too old.
See this time I'm gonna.
Don't forget that we have also spent some time on that side.
Not that. Not that matter. Can you see this? Because tomorrow, yeah, also another case of lordship there. So can we see?
Friday.
Friday. Friday.
Friday আবার একজন সিনিয়র আসবে দেখবে I'm sure. Yes.
For 25.
You're for the? Yes.
Against the matrimonial order.
First tell us the way things are moving. Are you ready with the appeal?
Well, the paper has been cleared.
হ্যাঁ গো কিরকম হলো পেপার বুক তৈরি হচ্ছে পেপার বুক কালেক্ট করলো না মামলা লিস্টে এসে গেল কি নোট দিয়েছি দেখো তো পড়ো
TCR 4 file মানে trial court record. Paper book has not been filed by the learned advocate for the appellant till date. So, when direction was given?
6th November. This is exactly what I
6th
was
November.
telling Mr. Ghosh. You will find in the warning list, paper books are directed to be collected. If you do not collect it,
Well, government record was taped with this.
When you receive notice of arrival of lower, and now lower court cannot be stated. Notice to appellant, 9th April 2025. 9th April only.
এখানে তো লজিমা কেস হয় না তলবলা জমাই দেয়নি মেসেঞ্জার কস জমাই দেয়নি জমা দিলে তো তবে লোয়ার কোর্ট রেকর্ড আসবে ও 6 মাস পরে হয়তো গিয়ে জমা দিয়েছে
Received on month of January received, ইয়ে হয়েছে দেখুন অফিস অফ কাজ করছে দেখুন জানুয়ারি মাসে লোয়ার কোর্ট রিসিপ্ট আর নোটিশ দেওয়া হচ্ছে ইন দ্য মান্থ অফ এপ্রিল
এইটা হ্যাঁ এইটা কথা বলে বলবে কি হয়েছে আমাদের দুজনের কাছে এর পরে এসে রিপোর্ট করতে এটাতে এমনি আউট হবে আউট অফ দি লিস্ট ইট ইজ সাবমিটেড বাই দি পার্টিস
লিখে নিন হ্যাঁ
it is submitted by the parties and also
the report indicates
also and is also borne out from the report placed before this court by the department that the paper book is not yet ready. Let this appeal go out of the list with liberty to mention after completion of the paper books.
Okay.
After the paper books are prepared. আর এটা আমাকে ইয়ে দিতে বলবে
Item number 26. Item number 26.
পাস ওভার করো
Item number 27. Item number 28. Okay.
Yes,
Therefore, not today.
you are holding only adjournment briefs.
You know, this case is Mr. Omnis trial just seek to the fluctuation of the blood pressure. That's why I could not come to you. But I just joined the Chandra. 2 days ago, that I could not prepare myself to the quality food. I'm taking part in front, not reading the
When you
Item 28.
For the appearance.
And for the respondent number 1.
That against an order of eviction. Where I have been ordered to evict, then I am submitting the degree. Where the degree was an ex parte degree. The subsequent to the ex parte degree, order 9 Rule 13 was taken out. That was rejected.
Now you have come up in a regular appeal.
There's a little bit more background. Well, after that, the appellant, due to the importance or will proper advice, prefer the revision before the latter district. Subsequently, it was not considered and not considered. Then an appeal was taken out before this honorable court. That was again rejected. Against that, an SLP was preferred. Honorable Supreme Court granted the liberty that if you prefer an appeal within 1 month from date, the court will not reject the ground of influence. So the delay was followed by the coordinates of this court. My stay was rejected because of the reason on the day when the stay was moved. The decree was already executed. So I was evicted from the court. So my appeal is this. And subject to the outcome of the appeal, I probably have my remedy under 144 of the code. Where I get preferred.
Your client is so serious.
The matter is serious because the entire backdrop is of a matrimonial dispute. In this
What is the property? What is the property about?
It's a dwelling.
Oh.
She is the wife of that house. Her in-laws are staying there. Her husband is staying there. Matrimonial disputes cropped up from 2017 onwards. Suddenly, 2019, an eviction suit was filed by the in-laws, claiming that it is a joint property. She has no right to stay over here. And then she got surreptitiously a decree was offered. That is our submission.
Is there a decree of divorce?
No. Matrimonial proceedings are pending. 498 and Domestic Violence Act, etc. Now, since on the face of this decree, my right to residence under the DB Act is not something where I am facing obstacles. I am outstanding. And in this house, I have lived for a decade. My 3 children was born in this house. Now, Millard, I have been treated as a.
It's not a question of see today what is her right, whether she is a licensee or she has as a right per se, because see today the right property, if it is a joint property, it may be of the father-in-law or it may be of the husband. Now, if it is a property of the husband, till there is no decree of divorce, she is entitled to decide over there.
That is precisely our cases. While obtaining the decree, what was suppressed is that there was a gift deed pursuant to which her husband has received the property. And there was a partition deed wherein, subsequent partition deed wherein the entire property was demarcated what is the portion of her husband. So this entire decree has been obtained by way of fraud. That is the case, madam. And the learned advocate who has whom this applicant has approached contest the suit, to whom he has given the signature and the wakalatnama, that learned advocate subsequently withdrew from the brief, saying that he drafted that partition deed within the in-laws. And by the time the brief was returned to me, or his refusal to defend the matter was communicated to me, by the time it was already on.
District Kuchbihar or?
This is precisely what the appeal is all about.
You want to start the hearing? We have no hesitance.
I
am led by Mr. Arun Kumar Sarkar in this matter.
Yes?
I am led by Mr. Arun Kumar Sarkar in this matter. And if kindly paper books are to be prepared.
With the stay application, all documents are annexed. You can treat it as an informal paper book and hear out the appeal. Because I am out of residence, there is some absence in the appeal. But paper books definitely, that is a formality which is usually complied with, that will take time. Can we consider this as an exceptional case and hear from the any day, Mr. Sarkar is senior, if subject to his availability, he can inform when.
The difficulty is that we can start, but if the trial court records are required, then all the records are there.
But mostly it is annexed with the stay application. So the stay application is now, it is disposed of. Stay has been rejected.
Trial courts, records are
You
required.
should have then gone for preparation of an informal paper book.
Milord can then kindly pass that direction. Milord, we can expedite that to the best that we can. Milord, we'll deposit the special messenger for immediately, Milord, so that records can be called for and we can prepare an informal paper.
Yes, this is an appeal. Against an decree of eviction. The appellant says that she has a right of residence in her matrimonial abode wherefrom she has been evicted in a fraudulent manner by suppressing material fact. It is also the case of the appellant that the eviction decree passed against her has been executed and she has been evicted from the premises in question. The matter is not a normal landlord-tenant dispute. We are told that there is no dissolution of marriage between the appellant and her husband. Respondent number?
The husband is not the respondent. The in-laws are the
Therefore, that there is no resolution of marriage between the applicant and her husband.
Husband. And as such, the question of denial of right of residence cannot be implemented. Denial of cannot be cannot be enforced against her. In the considering these aspects, instead of having the paper book prepared to the department, we direct preparation of informal paper book by the appellant after settlement of the index of the papers to be incorporated in the informal paper book between the parties. Settlement of index between the parties. Let sufficient number of informal paper books be made ready within a period of 2 weeks. 3 weeks. 3 weeks from date. After the paper book, after the informal paper book is ready, the appellant shall be at liberty to file to seek inclusion of the appeal in the list with reasonable notice to the respondents. The petitioner, the appellant shall also deposit necessary messenger cost for the trial court records to be brought to this court. To stop. In the event the messenger cost and other formalities are completed within a week from date, the department shall make an endeavor to bring the trial court records as expeditiously as possible for being placed before the court at the time of hearing of the appeal. Because no problem.
Item number 29, under random appeal hearing. Item number 29.
Adjournment. Adjournment. How many days? Next circuit. Monday. Sorry. Day after tomorrow. In the meeting, the bar will say that hearing matters are not taken up, and when it comes, no one is ready, only adjournment. That cannot be a good gesture.
Item number 30.
But in this case, my lords, I am the respondent writ petitioner. The writ order was in my favor, the revenue is there in appeal. They have filed a report, my lords. I need to file an exception to the report, my lords. I will take.
Who is appealing for the revenue?
My lords, Rima Sarkar appears for the.
Yes.
Miss Rima Sarkar usually appears for the.
Yes, Miss Rima Sarkar, I think, was there in the morning.
My request, my request, my lords, should be, my lords should kindly grant me time till the Friday and take up this matter on Monday, my lords. We want to do this matter before this bench.
Let us see, let us see.
They have already filed the report. It is for me to file the exception to her report.
Please wait. We are passing it over. Let Miss Sarkar come, then I will will pass the order.
Item number 32. Item number 32.
I'm praying for not this week election.
Day after tomorrow.
Item number 33. Item 34. 35. 36. 36.
The state of West Bengal is the applicant here.
Respondent.
Who is appearing? Do you have any idea?
Yes, Lord, because Shubham Ghosh. Shubham Ghosh was appearing.
We just inform him tomorrow what can be done.
What I'm saying,
Not today, করা কি করবে?
Item 37.
Item 37, 38, Lordship. I appear, Lordship.
Yes.
Colleague is there, Mr. Ajay Singhania. He's addressing your Lordship physically, Lordship, but.
One item, Lordship, filed by us, your Lordship, against the state DCEC, Lordship. That in fact, That's your lordship. There was a scheme for subsidy against the energy charges. Now we have paid the energy charges, but the government denied. If there was a direction to file an affidavit in a short point only, whether I have paid the energy charges or not, file a DCL. The report, evidence not filed.
You are whom? You are who?
I'm for the WBSC.
Huh?
WBSC.
WBSCDCL.
Licensing company.
The licensing. Now, what is the dispute? Dispute is,
Lordship, may I kindly apprise Lordship?
yes,
Lordship, this appeal arises, this is two connected appeals, Lordship.
yes.
Lordship, the item 37 is my appeal, Lordship. We had been able to obtain a favorable order in our writ petition, Lordship. The writ petition, we were we had prayed for certain subsidy to be granted from the state in light of a scheme of 2007. That scheme granted subsidy to MSME companies and an extra subsidy to women entrepreneurs in MSME companies for energy charges. Now, under the scheme, I was entitled to certain subsidy, Lordship. I had demanded that subsidy. I had filed a writ to that effect, Lordship. I was sent back for assessment to the state board. That assessment order was held against me. Hence, the writ petition was filed, Lordship. In the writ petition, Lordship, learned single judge was allowed to grant me the principal amount claimed by me. However, since the subsidy amount was of the year 2015, Lordship, I was aggrieved by the non-granting of the interest. As in as much as the learned single judge had not mentioned anything about the interest, Lordship, even though it was prayed. So my appeal is only restricted to the interest portion of the grant, Lordship. However, subsequently, Lordship, the state also filed an appeal, Lordship, assailing the entire writ petition order. Now, Lordship, these two connected appeals were first being heard in the principal bench that thereafter got transferred to the Jalpaiguri bench, Lordship. They were renumbered over here, paper books filed, Lordship, all affidavits complete, Lordship. There's nothing pending in terms of filing. However, Lordship, this, if I may kindly also apprise, Lordship, that because of the limited tenure of the circuit benches, there's 2 weeks, this matter has been heard and reheard multiple times, Lordship. And Lordships will find that on the previous 2 circuits, the matter had really been crystallized to certain specific issues, and that specific issue was sought to be clarified by a direction on the licensee company, for them to prove whether to put it on affidavit, whether we had paid the energy charges or not. That's it. Because the singular point of the state's appeal was that the energy charges, that I had not attached the money receipts for the energy charges, Lordship. So on that point,
my lord, I am representing WBSCTCL with Mr. Anirban Banerjee, my lord. We have on earlier occasions, we have already, my lord, filed an affidavit, but due to some technical ground, my lord, that was by payment objection raised by my learned friends. That was, my lord, not.
See, tell me one thing. You are the licensee.
So that, my lord, we can reaffirm the same and file the copy.
Tell me one thing. You are
because, my lord, so far we are concerned. We have nothing to say. My lord, only to confirm whether they have paid the energy charges or not. That has been confirmed.
Mr. Kole, the difficulty is you are Mr. Kole.
My lord,
Mr. Kole, the difficulty is that suppose I do not annex the energy charges payment receipt. Now, this is one of the ground taken by the state. The law to which we are aware of, that certain admitted facts are not required to be proved. Now, if the assessee did not pay the energy charges, then definitely you would have taken action against them.
Well, they have paid. They have paid.
So, why is this issue? Energy charge payment is being again looked into.
That will not.
So
really,
grateful, Lordship.
Really, we are really appreciate your. And so far we are concerned, my lord. It has been confirmed that they have paid everything.
Lordship, if I may kindly make one more small submission, Lordship. Lordship will take up the last two orders, Lordship, mainly the order dated 15th May, Lordship. In that order, Lordship, there was a direction to file a report or in the form of an affidavit, Lordship. Lordship will take up last 2-3 orders, Lordship, 1st May and 15th May. Lordship, this report that is spoken of in the orders, Lordship, had been filed at the last occasion, Lordship. However, as my learned senior friend, Mr. Kole, just apprised, due to some technical defects, it could not be taken on record. Lordship, I am led by Mr. Krishnaraj Thakkar, senior advocate, Lordship, in the matter. He would like to physically come there and argue the matter, Lordship. Lordship, however, in absence of this affidavit being on record, it is
Mr. Thakkar is a very slippery customer. We do not know whether he will be available.
No, Lordship, I am confirming on his behalf, Lordship. I have taken that instruction and liberty, Lordship, from him, authorization to confirm that he will be there physically, and he has given me his word.
When?
Lordship, next Tuesday, Lordship, on 17th, Lordship, next Tuesday.
That is the whole difficulty. 17th, we don't have much time. Suppose it spills over Friday, we don't want to keep any major hearing matters because.
Lordship, but in the absence of this affidavit from the licensee company confirming, even though verbally it has been submitted that I am.
Where is the affidavit? Licensee?
It could not be because the officer could not come. Kindly keep it up on Monday or Tuesday in the meantime.
But have you served the advance copy?
Lordship already, sir.
Already,
Lordship, there's a technical ground. Show your Lordship.
What is the technical ground? Everybody is saying
it was notarized, your Lordship. It was notarized at Calcutta.
So what
the
is
state government, Lordship, the state vehemently opposing.
Where is the?
We have already received all the.
Yes, although
notarized affidavit, if it is stamped and punched over here, it is to be taken on record.
Yes. Lordship, that was what we submitted in the previous circuit, Lordship. It could have been done and dusted in the previous circuit, Lordship, but
yes, and previous circuit. Previous circuit bench has already inclined to take up the affidavit, taken on
and
record.
trash out the matter, Lordship, because really, like your Lordship pointed out, it is on a singular point that the licensee is confirming my payments.
Lordship, in order sheet also, or honorable division will record the submission of the WBC, they paid the energy charges.
So your appeal, what is your
for interest, your Lordships? Earlier in the writ petition, Honorable Justice Sabakti Chatterjee allowed the writ petition and directed to pay the principal amount. We agreed, Lordship, for interest, your Lordship.
Lordship, Mr. Singhania is there as my colleague physically over there, Lordship. The state advocate's appeal is the second appeal.
Who is appealing for the state? Who is appealing for the state? Who is appealing for the state?
We are for this.
What is the dispute? To which part you are aggrieved?
First, they have showed different bills of the electricity company,
Yes.
but they have failed to produce the money receipts.
Now the money receipts are there.
No, they have failed to, and the bill was raised, arrear bill. So what is the arrear? The scheme was for 5 years, that we will be providing subsidy for 5 years. The bills were raised, yes. We have paid the subsidy amount.
Lordship, in the energy charges, as the tariff, your Lordship, the energy charges. Now subsequently, WBSCD.
You are not required to explain me. What happens if suppose you are paying at the rate of say 10 rupees per unit.
Yes.
Now there is a reappreciation of the rate by the Electricity Regulatory Commission. Now Electricity Regulatory Commission suppose fixes the rate at 12 rupees. So he has paid at the rate of 10 rupees.
12 rupees.
No, he has paid at the rate of 10
10
rupees.
lakhs.
So these 2 rupees will be collected from him in installment over a period of say 6 months or 8 months in this manner.
So
This is
grateful,
what
Lordship. So
this,
grateful.
this
That
is the this is
that-
the area this is the area bill.
Lots.
So
And
great.
title on the area
So
data.
grateful, Lordship. Now that subsidy, that scheme is now also to be, I also wish to avail the scheme for the arrear, for the 2 rupees, Lordship. That is squarely my claim, Lordship, and which was on the basis of a no dues certificate was granted by the learned single judge, Lordship. However, we were only
Now you have to show you have to demonstrate that these areas pertain to the period for which the tax holiday or the
Lordship, if I may kindly say, Lordship, this is not even in dispute. The question that just fell from your Lordship, this is not even in dispute. The arrears, by their representation, pertain to that period, Lordship, in which the scheme is promulgated. That is not even a point of dispute, Lordship.
very well. Next Tuesday.
And Lordship, direction to file that affidavit from the state, from the assignee, Lordship, license.
That they will do. That they will do.
So grateful, Lordship. So grateful.
Item number 39. Item number 39.
Yes. Lots 39, 40 and 41. Union of India is the appellant. Lordship, Lane D is the arguing counsel. But if fix this Monday, we are ready for hearing. Matter is ready for hearing.
Who is your who is the
Mr.
respondent?
Ghosh, Vikramaditya Ghosh, your Lordship. Next week, any day, your Lordship.
Very well. Next Monday.
Lordship.
What you have? So, what you want, Tabra, hearing land.
Item number 42. Item number 42.
The criminal appeal number.
I am the petitioner, made by Mr. Honorable Chatterjee in this matter, and can you take the matter on?
We are not interested by the name or fixing the matter on a particular day. You do it.
My lord, I am appearing for the respondents, my lord, the private respondents. Am I audible and visible?
Yes.
My lord, I was appearing for the private respondents. I am the affected party by this appeal. My lord, if it commends to my lord, if your lordship can please accommodate me, my lord. If your lordship kindly takes this matter up on next Monday, my lord, then I can be physically present because this matter, my lord, is very difficult to do.
Subject to my lord's convenience.
Monday.
Grateful, Lord.
I am deeply obliged, my lord. I am deeply obliged.
কিছুই হবে না সোমবার সবাই সোমবার চাইছে কিছুই হবে না সোমবার No, you will earn your outstation fee and Mr. Chatterjee will earn his outstation. Nothing more than that.
My lord,
আচ্ছা ওই একটা পাস ওভার ছিল না ওই সরকার there is a passover matter. Who is your yes. No, exception they were asking for. You have filed a report. They were asking for a yes.
Jagriti Mishra is there, my lord.
Yes.
I'll call him, my lord.
Yes.
My lord, I'm deeply obliged, my lord. I only want to submit this, my lord, that your lordship was leading us also in the bar. That time your lordship goes by. Your lordship was with us, my lord. Yes, another thing that your lordship, my lord. I'm deeply obliged, my lord. I'm deeply.
let this matter appear on 16, 17 to 18 তারিখ। Which item is this one?
Item 30 connected with 31. Because the lower court records are called for, therefore the writ petition is also there, that is numbered as 31.
এটা এরকম হয় নাকি?
We also often get confused when we.
হ্যাঁ, এই মলয় আমাদের ওখানে তো এরকম হয় না, উইথ করা থাকে তো।
হ্যাঁ, with would be there, but
এখানে with আছে
করা separate item number would not be there.
না উইথ থাকলো আইটেম নাম্বারটা ওইটা পড়ে।
ও আইটেম নাম্বারটা তাহলে পড়ে না,
ওখানে আইটেম নাম্বারটা পড়ে।
ওখানে কন্টেম্পটে আমি দেখেছি রিপিটিশন থাকলে আইটেম নাম্বারটা পড়ে, এখানেও পড়ে আর খেয়াল করিনি আর।
বিপ্লব
এখন এটা হয়েছে কবে থেকে কম্পিউটার এইটা হয়েছে, এবার যখন ওই সার্ভার বলতে যায় তখন নাম্বারে কিন্তু সিরিয়াল নাম্বারে বলে উইথ থাকলে ওটা তো একটা কি অর্ডার আপাতত মিলে মিলে
ডাকতে থাকো দেখি কটা হিয়ারিং হয়। হ্যাঁ দেখি না। Yes? Item number 7. Who is for the, that matter, both of you are present.
Come to.
Will it be possible to complete you within 15-20 minutes? What is the matter about?
My suit for partition and declaration was dismissed.
On what ground?
I have claimed that total partitionable property is 11.5 acre, 11.05 acre, and subsequently defendant appeared and said the father during his lifetime has gifted away some property to the defendants.
How much property?
5 acres, 5 acres, and they have admitted that total partitionable property now remains 5 point some odd amount.
Yes.
That is the partitionable property according to the defendant.
Yes.
But the learned court entirely dismissed the suit, and we have challenged the gift deeds also on various grounds, and that grounds are not considered.
Gift deed means
gift deed executed by my father
in respect of the 5
acres.
5 acres.
And that gift deed was not attested by only one witnesses.
Their specific plea was that the acceptance was not executed. The Tony was not endorsed in the gift deed. Learned lower court held that in view of 120 and 123 of the TP Act and two judgments of the Honorable Supreme Court that was relied upon, there is no requirement of specific acceptance. Since the attesting witnesses and the scribe was examined, nothing further remains, and in pursuance of the gift deed, ROR was issued. So that was acted upon, that is implied acceptance.
I have challenged the gift deed on 2 grounds: that it was not accepted during the lifetime, and it was not, and I have challenged the execution, and they failed to prove that it was actually attested by 2 witnesses. Because some gift deeds specifically state that it was out of 5 gift deeds, 2 deeds have been attested by the 2 witnesses. And 3 deeds have been attested by only 1 witness, and that is evident on the face of the deed. So my challenge was that since it was not properly attested according to the and it was not proved, so gift deeds cannot be considered. And although acceptance can be,
there was a direction upon me to file an opposition to the stay application. Now, instead of that, subject to your lordship's approval, let the lower court records be called for. The paper books will be prepared and this appeal goes for final hearing. So that will cut it short, because opposition means I will be reiterating all what I have relied in the lower court, the same thing I will annex. And
can one be discussed by making my
Can one for stay? Can one for stay, application for stay?
Injunction, application for injunction.
There is no prima facie case, madam.
No,
There is no prima facie case. Due to my non-appearance,
ad interim was granted.
ad interim status quo was granted due to my absence on repeated occasions because I received the instructions on the brief. So the
স্টে অ্যাপ্লিকেশনটা শুনে নি দিয়ে ও অ্যাপিলটাকে হচ্ছে ইয়েতে পাঠিয়ে দিই,
as you learned.
স্টে অ্যাপ্লিকেশনটা শুনে ডিসপোজ অফ করে দিই।
For that, Millard, sufficient papers are there with the stay application. So if Millard kindly takes it up probably tomorrow, Millard. Now it is already 4:50. The extreme heat outside.
Oh, not today, করে রাখো। Not today, হ্যাঁ। Yeah. ওদের কোয়ার্টার গুলো মশারি আছে। ইয়ে নিয়ে চলে যাও, কি বলে দেখি ক্রিমিনাল হিয়ারিং কি বলছে, লিখে দাও না, লিস্টটা লিখে দাও।
53 under any criminal appeal hearing. Item number 43. 44. 45. 46. 47. 48. 49. 50 with 51. 52. 53. 54. 55. 56. 57. 58. 59. 60. 61. 62. 63 with 64. 65. 66. 67. 68 with 69. 70 with 71. 72. 73. 74. 75. 76. 77 with 78. 79. 80. 81. 82. 83. 84. 85. 86. 87. 88. 89. Under heading for hearing death reference with 90. 91 with 92, 93.
Lordship, item number 29 and 32, I would like to mention, kindly keep the matter tomorrow, Your Lordship. Day after tomorrow, my learned senior's father is having a surgery, Your Lordship. Will not be possible.
If you have mention it tomorrow when it is called on.
Item number 29 and 32.
You should have mentioned it when the matter was called on. This is not the time to mention.
Lordship, it was day after tomorrow, it was fixed, listed, Your Lordship. I will make it tomorrow. 29, 32. Kindly make it tomorrow, Your Lordship.
Your other side is not there. Now today,
I shall inform you.
ওরা করে দাও, কালকে করে দাও। You inform your other side.
I shall.